Hello and welcome to another session on current issues. In this video, we will try to understand the recent controversial film Kerala Story. It should be noted that the film Kerala Story raised several objections from Muslim organizations, student organizations, NGOs, parties across India, so on and so forth. The film, as per the makers' point of view, is showing the story of 32,000 girls joined in ISIS. However, recently the filmmakers changed the keywords in YouTube from 32,000 to 3 girls joined in ISIS. Notwithstanding with the Kerala Story film, we will try to understand similar incidents happened in India. We will see Supreme Court judgments on this issue. Well, before going to start the narration, I would like to quote French philosopher Voltaire. The right to free speech is more important than the content of speech. The idea is every human entitled to have the right to free speech. Further, Constitution also guarantees you freedom of speech and expression in fundamental rights. In understanding the film banning or sanctions over a film, Constitution explicitly mentioned that 7th schedule of Indian Constitution, list 1 entry 60 talks about sanctioning a film by the union government. List 2 stated theatres and dramatic performances comes under state list. Further, it mentions cinema subject to provisions of entry 60 of union list. Here one should remember that states doesn't have explicit powers on banning a film. So this background information is important for us to dive into the topic. Previously, I think in 2018, Padmavat, a film, created a similar kind of controversy. A group of people who belongs to Rajput community organized Karali Sena and they started to work out on against the film release. They demanded ban. However, Supreme Court refused to ban, similar to Kerala Story issue. Constitution in 19 clause 1 implicitly mentioned about freedom of speech and expression. The word expression includes your writings, songs, even projecting a movie. One should remember Kanche Ailaya, a person who wrote a controversial book which disrespected a community in Andhra Pradesh, to quote Vaishya community in Andhra Pradesh. It was banned by the relevant governments, but judiciary removed the ban and allowed Kanche Ailaya to publish his book. That is, freedom of speech and expression includes not only uttering the words or statements, it also includes the freedom of publishing a content material, even a movie. Unlike USA Constitution, where you can find that direct reference to the freedom of press, here we don't find freedom of press explicitly in the Constitution. Moving further, the idea of censorship was brought into the Indian modern governance by British. Here, Britishers never accepted criticism against them. So the idea of censorship, which is affecting public morality, promoting obscenity or nudity or hampering the peace, those publications or those media outlets will get censorship. In 1918, they created Censorship Act. Further, we have to understand that censorship is a tool to impose reasonable restrictions by competent authority from the example of British administration. After independence, we have Cinematography Act 1952, which created a competent authority in the name of Central Board of Film Certification, CBFC, which will provide you certification to the films like A and U by A, like that. Now, when several cases were filed in Supreme Court with respect to different films, we will examine some important judgments given by the Supreme Court. On the first instance, we will try to observe K.A. Abbas versus Union of India case. In this case, Supreme Court mentioned that courts supposed to have a balance or should have an idea about pre-censorship and even censorship or restrictions. It clearly stated that cinema is a medium of expression, can be treated differently from the other forms of art, because cinema can bring a lot of emotions and it can also raise sentiments among the people. Cinema has a huge impact on children, adolescent people, and even society itself. So that's the reason pre-censorship of cinema doesn't violate freedom of speech and expression under Article 19 Clause 1. In fact, Article 19 Clause 2 stated reasonable restrictions on freedom of speech and expression, on security of the state, morality, decency, public order, so on and so forth. So, pre-censorship was allowed by the court in this K.A. Abbas case. K.A. Abbas versus Union of India uphold the validity of pre-censorship of films. For book publication, you don't find such pre-censorship. For newspaper publication also, you don't find it. But for films, you will find it in India. One should remember that this was upheld by Supreme Court in this case. The next famous case in this regard was Oru Oru Gramathile. Oru Oru Gramathile movie showing some kind of reservations issues and sensitive issues regarding some caste beliefs in the movie. This film got a huge protest from the people, and a case was filed in the name of S. Rangarajan versus P. Jagjeevan Ram. It was in this judgment, Supreme Court clearly stated that violence or initiation of violence by the public should not restrict the freedom of speech and expression. The same words repeated by Supreme Court in many cases. The public violence or initiation of violence by the public should not be a reason for banning the film. In fact, demonstrations or protest by the public can happen, but it should not restrict the film, because it is restrictions on the films of the film is affecting the 19 clause 1, that is a fundamental right to the person. So Supreme Court in this judgment clearly stated that merely protest from the public or merely a group of people objecting the film should not ban the movie. In Bobby Art International versus Om Pal Singh Hoon case, which is a case which demanded banning of Bandit Queen, which is based on the Poolam Devi story, Supreme Court said it cannot ban the film. It cannot ban the film on the grounds of abusive language or nudity. Instead of that, it stated that CBFC, is aimed to delete such kind of obscene scenes or nudity scenes or abusive language. That is allowed, but banning of the film on the such grounds is not allowed. So you should understand that Supreme Court clearly supporting Article 19 Clause 1, that is freedom of speech and expression, continuously. Finally, very recently in 2019, Government of West Bengal banned this film, Bobby Shotar Booth. In this Bobby Shotar Booth movie, ban was imposed as it is going to initiate mob violence in the Bengal region. Supreme Court struck down the ban and stated in this Indibili Creative Private Limited versus Government of West Bengal that freedom of speech and expression is not restricted by fear of mob violence. So it is also, so in this judgment also Supreme Court supported the publication of so-called making of films and film release in India. Finally, in Viacom 18 Media Private Limited versus Union of India, it lifted ban on Padmavat movie imposed by several states in India. From all these examples, I would like to conclude that filmmaking or production of films comes under fundamental rights. It should not be restricted or it should not be affected by means of problem to law and order or protest by the people or obscenity or nudity. Filmmaking is one of the essential core part of our freedom of speech and expression. It should be regulated, it should be pre-censored by K. Abbas case, but it should not be outrightly banned in a mature democracy like India. I would like to say that from the judgments of Prakash Jha production, that is Arkashan judgment in 1989, or even S. Rangarajan versus Jagjeevan Ram judgment in that Tamil movie, Supreme Court clearly stated that if people are protesting against any film, the maintenance of law and order is a duty of the state. It should maintain the law and order. Merely by showing films, merely by projecting films are doing certain wrong things, we cannot ban the films. That was the Supreme Court stand in this point of time. And it also mentioned, as we discussed in the early of our, in the beginning of our topic, that is entry number 33 and 60 talks about the regulation of the films. And finally, you should remember that Walter even stated, I disapprove what you say, but I will defend to the death your right to say. So a filmmaker do have a right to say. He even has a fundamental right to visualize his expression, to write his expressions, and he can deliver what he is feeling to write or to make the films. So based on this, we can say that without freedom of thought, there can be no such thing as wisdom, no such thing as public liberty without freedom of speech and expression given by Benjamin Franklin. So one should important that banning a film is not correct, but pre-censorship, regulating it is most important thing at the point of time. Let us wait and watch what will happen in the Kerala story case. Thank you so much and Jai Hind.